I'm going to be talking about the ways in which gender identity activists have been trying and are still trying to close down gender critical speech in England and Wales. I'm going to focus on England and Wales. Maureen's going to talk about Scotland. And I'm going to focus particularly on how the courts have responded to this and how, in some ways, the courts have contributed to it. I'm using the term gender critical because whether feminists call ourselves gender critical or gender abolitionists, we're all critical of the concept of gender identity, but also because the term gender critical is now being used in the courts and understood in the courts, which is helpful to us. So that's the terminology I'm going to use. I'm going to start off talking about the kinds of silencing of women that have been going on in recent years in England and Wales, particularly since the consultation on government proposals to reform the Gender Recognition Act 2004 to introduce self-declaration, which hasn't happened and may not happen. But there was a very concerted attempt during the consultation on that reform to silence women's voices on it. In 2017, Maria McLaughlin was assaulted while she was waiting to attend a public meeting about the Gender Recognition Act reforms. And one of her attackers, Tara Wolfe, who is male and self-defines as a trans woman, was convicted of assault by beating of Maria in April 2018. The attack on Maria McLaughlin was the most extreme action taken by gender activists who are trying to prevent feminist discussion and feminist meetings about the proposed reforms. Particularly when the meetings first started, they regularly pressurised venues to cancel meetings, they harassed women going into meetings, and they did their best to shut the meetings down. They didn't succeed though. Most of the meetings went ahead. And since the consultation, there have been relentless attacks on women's freedom of expression by gender identity activists. They've targeted some men as well. Women who publicly question gender identity ideology are routinely verbally abused on social media, and they're often reported to their employers for alleged transphobia, and many women have been fired as a result. In some cases, activists have reported people to the police, making allegations of hate speech. There's no specific legislation in this jurisdiction which talks about hate speech, but there are public order pieces of legislation and legislation controlling communications on social media, for example, that activists have tried to use to silence women. Most of the time they haven't succeeded in doing that. They've tried to get women prosecuted. In some cases they've brought private prosecutions, as with the private prosecution against Linda Bellos and Dennis Allen, but that didn't succeed. The CPS threw it out in the end. But there has been one case in which a woman was prosecuted and convicted, and that was under the Communications Act 2003, which regulates public communications, including communications on Twitter. Her name is Kate Scotto. She was convicted of causing annoyance, inconvenience and anxiety because of things that she'd said in a Twitter exchange with a trans-identified male. She'd used male pronouns to describe him, and she also called him a pig in a wig, which is an offensive remark, but it's not as offensive as a lot of the remarks that take place routinely on Twitter, against which no action is taken, either by Twitter or anybody else. Women receive rape threats, death threats, obscene insults of various kinds, and they don't generally result in any criminal conviction. At court, the judge told Kate Scotto, "We teach our children to be kind." As far as I know, being unkind is not a criminal offence, and it isn't the role of the courts to police social niceties and try to make people be civil to each other. But Kate Scotto now has a criminal record as a result of that Twitter exchange. And it was an exchange, it was back and forth between the two of them. She didn't seek him out and target him out of the blue on Twitter. I think attempts by gender activists to control speech can be seen as taking two separate but often overlapping forms. One is the suppression of gender critical speech, and also speech which acknowledges female biology. For example, some organisations who public health information are now calling women uterus havers, menstruators, and people with cervixes. And women who object to being erased and dehumanised by that kind of language are attacked as bigoted and transphobic. And recently, this happened to a Labour MP, Rosie Duffield, who's been targeted on social media and by the LGBTQ and whatever else section of the Labour Party, I can't remember how many letters they use, as transphobic for saying that only women have cervixes. I think recently she's apologised for it after a lot of pile-on. Okay, the other form of speech control is compelled speech, which involves the imposition of forms of speech which acquiesce in the acceptance of gender ideology. And the most common form of that is the forced use of preferred pronouns. No other political movement which claims to be promoting equality and social inclusion has ever attempted to control public speech in this way, certainly not to my knowledge. And I think the reason why the gender identity lobby does this is because they know that they can't achieve their aims by changing public opinion through debate. Hence their mantra, no debate. The social changes they have achieved so far have been brought about largely by stealth and often through a process of policy capture. They have very explicit, in some documents they've explicitly stated they want to avoid public scrutiny and work behind the scenes. But in public arenas, the other side of that is bullying and threatening of people who disagree with them. Their ultimate aims are set out in the Yogyakarta principles, which we talked about at length last week. I'm not going to talk about them in detail. These are principles which claim to promote the proper application of international human rights standards in relation to sexual orientation and gender identity. In reality, they focus pretty exclusively on gender identity. They have no formal status in international human rights law, but they're promoted constantly as international best practice, and they have a lot of influence. This slide is a quote from Principle 31 of Yogyakarta Principles Plus 10, which was an additional set of principles. And it summarises their ultimate aims. I won't read it out word for word, but essentially what it says is, their aim ultimately is the removal of all sex and gender markers on identity documents such as passports, birth certificates, and so on. So there will be no markers recording sex in any kind of public sense. And in the meantime, before this can happen, they want absolute self-declaration of gender identity to be brought into law, with no gatekeeping and no exceptions based on age or on mental capacity or on a person's criminal record. Now, the aim of removing all sex markers from public records will never, in my opinion anyway, be accepted by the majority of people, most of whom would see it as extreme and divorced from reality if they knew about it. Most people don't know that this is the aim. Most people understand that biological sex is significant in one way or another, even if they don't view its significance in the same way that feminists do. And so the removal of sex as a social and legal category can only come about through policy capture and through the suppression of debate, so that in the hope that most of the public will not know what the agenda is, and that's one of the reasons for suppressing debate about it. The attacks on freedom of expression, which are directed at individual women and women's groups who question gender identity, are mirrored at a policy level in some organisations in the public sector, and this includes the courts. While Maria McLachlan was giving evidence at Wolf's trial for his assault, the district judge in the magistrate's court told her to call Wolf she or the defendant as a matter of courtesy. She said that she tried to do this, but she was nervous while giving her evidence, as everybody is giving evidence in a criminal trial, and she kept referring to calling Wolf as he because that's how she perceived him. The judge described this as bad grace and gave it as one of his reasons why he was not going to award her financial compensation for having been assaulted, which he could have done. The guidance, which is the source of the judge's attempts in that case to prevent a witness in a criminal trial from describing events in her own words and to compel her to describe the defendant using language which belied her own perceptions of reality, is known as the Equal Treatment Bench Book, which is guidance for judges on equality, and it has a section on transgender witnesses at court. And this is a quote from it. Showing respect for a person's gender identity includes using appropriate terms of address, Mr., Mrs., Ms., pronouns he, she, and possessives, his, her. Non-binary people may be preferred to be referred to in gender-neutral terms, e.g. mucks, I think, I'm not sure, they and their. Whilst gender neutral terminology is not yet mainstream, this should be accommodated wherever possible. And this section of the bench book is clearly written by lobbyists. And in fact, earlier this year, when the Law Society Gazette did a piece, when Alison Bailey and Harriet Wistrich were interviewed in the Law Society Gazette, it's a kind of solicitor's trade journal, they asked the Judicial College, which publishes the bench book, who had written it, and they wouldn't say. They said it wasn't in the public interest for people to know that. So that confirmed my view that it was written by a lobbying group. If you read it, some of the language in it is very clear. It sounds as if it's Stonewall talking, and possibly is, I don't know. The guidance raises serious questions about the fair treatment of witnesses at trials involving defendants who identify as transgender, particularly where the witness is a complainant, that is the person making the allegation. The logic of the guidance is that a complainant in a rape trial can be required to call a rapist she, and by extension, it could also require her to use female possessive pronouns to refer to body parts, which she would have to refer to in order to describe what happened. For example, she could be forced to say her penis when describing experiences of rape by a male who identifies as transgender. And that could apply to child witnesses and vulnerable adult witnesses. The bench book doesn't say it doesn't apply to them. And the guidance really has given no thought to how a child or an adult, for example, with learning disabilities, might experience an instruction from a judge, an authority figure, to call someone they perceived to be male as she, let alone, and it doesn't discuss how any witness will experience that. It's a type of compelled speech that undermines access to justice, in my view, particularly for women and children, because the right to accurately describe the sex of perpetrators of physical and sexual violence is crucially important to the ability to report violence and to give evidence against perpetrators. This type of compelled speech, I think, gives rise to a breach of witnesses' rights under Article 9 and 10 of the European Convention on Human Rights, which protect the right to freedom of thought, conscience and religion, and the right to freedom of expression, respectively. And the belief in gender identity is a political belief, as are gender critical beliefs. And it's well established in the case law of both the European Court of Human Rights and the UK Supreme Court that it's a breach of Articles 9 and 10 to compel someone to express a political opinion that they don't agree with. That was decided, for example, in a pretty well-known case called Lee and Asher's Baking Company, which some media called the gay cake case at the time, where it was found that the bakery were happy to sell a cake, but they wouldn't ice on the cake the slogan "Support Gay Marriage." Originally, they were found to have discriminated against him. It went as far as the Supreme Court, and the Supreme Court said no. If they'd refused to provide the cake, that would have been discrimination, but they didn't. Refusing to write a slogan that you disagree with is not discrimination, because people are protected under Article 9 and 10 from being forced to express political beliefs with which they don't agree. A case involving the suppression of gender critical speech and ultimately also compelled speech is the case which Mayor Forstater has brought in the Employment Tribunal. In May last year, she lost her job at the Centre for Global Development, a think tank based in London and Washington, for sharing gender critical opinions on Twitter. CGD refused to renew her contract at the time. Complaints about the tweets had been made to the Human Resources Department there. She'd shared campaigning material about the potential impact of the proposals for self-ID or self-declaration, and she'd also sent tweets which essentially said men cannot literally become women. She brought a case, as I've said, and she argued that her gender critical beliefs are a philosophical belief and as such should be protected under Section 10 of the Equality Act. In order to be protected under the Act, a belief must satisfy 5 criteria, which are known as the Granger criteria. One of those is that the belief must be worthy of respect in a democratic society and not be incompatible with human dignity and not conflict with the fundamental rights of others. The judge found that Mayor Forstater's beliefs failed this criteria. This is his summary of her beliefs. The core of the claimant's belief is that sex is biologically immutable. There are only two sexes, male and female. She considers this a material reality. So do most people, I think. Men are adult males, women are adult females. There is no possibility of any sex in between male and female, or that a person is neither male nor female. It's impossible to change sex. She will not accept in any circumstances that a trans woman is in reality a woman, or that a trans man is a man. That is the belief that the claimant holds. While the claimant will, as a matter of courtesy, use preferred pronouns, she will not, as part of her belief, ever accept that a trans woman is a woman or a trans man a man, however hurtful it is to others. And that was what he considered to be not worthy of respect in a democratic society. He went on to say, I conclude from this and the totality of the evidence that the claimant is absolutist in her view of sex, and it's a core component of her belief that she will refer to a person by the sex she considered appropriate. The typing errors here are in the case report, they're not mine. I just reproduced it verbatim because I didn't want to change it. She will refer to a person by the sex she considered appropriate, even if it violates their dignity and or creates an intimidating, hostile, degrading, humiliating or offensive environment. This approach is not worthy of respect in a democratic society. And he went on to add, which he didn't need to do because he wasn't asked really to address this, I do not accept that this analysis, he means his analysis, is undermined by the decision of the Supreme Court in Leon Asher's, that's the case I just referred to, the Cake case. That person should not be compelled to express a message with which they profoundly disagree unless justification is shown. The claimant could generally avoid the huge offence caused by calling a trans woman a man, without having to refer to her as a woman, as it's often not necessary to refer to a person's sex, it should say, at all. However, where it is, and I think this is significant, I consider requiring the claimant to refer to a trans woman as a woman is justified to avoid harassment of that person. As I said, this goes beyond his role in the case. It wasn't about alleged misgendering in the workplace. It was about determining whether Mayor Forstater's beliefs were protected by the Equality Act as a philosophical belief. He wasn't required to comment on a hypothetical situation in this way. So he went beyond what he was required to do. Mayor Forstater intends to appeal, and many lawyers, including the feminist QC Karen Monaghan, think that she's likely to succeed. Karen Monaghan practices employment law, which I don't. I'm not an expert in employment law. She thinks it's very likely to succeed, and she's written a blog about the case in UK, or written an article about the case in the UK Labour Law blog. I'll put a link to that on the presentation when it's uploaded to the website. I think it's a useful article to read. It's a good article in relation to this case. One reason for the optimism about Mayor Forstater's appeal is the judgment in a judicial review brought by Harry Miller against the College of Policing and the Chief Constable of Humberside, in which the High Court took a very different approach to freedom of expression in relation to gender critical views and the Employment Tribunal took in the Forstater case. Harry Miller brought two complaints. I'm only going to have time to discuss one of them in any detail. Miller's tweets were reported to Humberside Police as transphobic by one member of the public. The police didn't think he had committed any criminal offence, but nevertheless, one of them went to his workplace to talk to him about the tweets, and when he wasn't there, left a message with work colleagues, which he said was very embarrassing for him after that. And then later, he had a telephone conversation with a police officer who told him that if he continued to tweet about transgender issues, it was possible that the content of his tweets would escalate to the point where they would constitute a criminal offence and he could be prosecuted. The police also recorded his tweets as non-hate crime incidents. This is an incident which is perceived by the victim or any other person as motivated wholly or partly by hostility or prejudice, but which doesn't amount to a criminal offence. The police record those in all instances where an alleged hate crime is reported to them. The judge questioned whether the police should have recorded Miller's tweets in this way for various reasons, but he didn't accept Miller's claim that the policy regarding the recording of non-hate crime incidents was the breach of Article 10 of the European Convention because it was a suppression of freedom of expression. But in relation to the police visits and the comment about potential criminal prosecution, the judge ruled that the police had disproportionately interfered with Mr. Miller's right to freedom of expression, as his gender critical beliefs were protected under Article 10 of the European Convention, which I think is significant and potentially helpful in the future. The judge said the effect of the police turning up at his place of work because of his political opinions must not be underestimated. To do so would be to undervalue a cardinal democratic freedom. In this country, we have never had a Checker, a Gestapo, or a Stasi. Warning the claimant that in unspecified circumstances he might find himself being prosecuted for exercising his right to freedom of expression on Twitter had the capacity to impede and deter him from expressing himself on transgender issues. In other words, the police actions taken as a whole had a chilling effect on his rights of freedom of expression. And there's a large number of European Court of Human Rights cases, as well as Supreme Court cases in this jurisdiction, which emphasise the significance of being able to participate in public debate about important political issues and the importance of Article 10 and Article 9 in order to enable people to do that. In the Miller case, Jodie Ginsberg from Index on Censorship made a statement in evidence in which she said that Index on Censorship is concerned about a growing number of cases in which the police are contacting people about online speech which is not unlawful and asking them to remove it from social media. And she stated, the confusion of the public and police around what is and what is not illegal speech may be responsible for artificially inflating statistics on transgender hate crime. I think that's extremely likely. Police actions against those espousing lawful gender critical views, including the recording of such views where reported as hate incidents, creates a hostile environment in which gender critical views are silenced. This is at a time when the country is debating the limits and meaning of gender as a legal category. The judgment in Miller is a positive step in challenging speech control, and it may help Mayor Forstater's appeal. However, there's still a long way to go in challenging and reversing the degree of control over public speech, and particularly women's speech, which the gender identity lobby has achieved in the last few years. And one of the key aspects of that is going to be challenging the bench book, which some of us are working on at the moment.